Well, hello, everybody. My name is Jody Collopin, and I'm a judge in South Africa. I sit in a court that's called the North Gauteng High Court, which is located in Pretoria in the province of Gauteng. And I was going to say good afternoon to everybody until I realized that we're joined by people from different parts of the world who are in different time zones. And for some, it may be morning, for some, it may be evening, but welcome to all of you. It would have been wonderful to have had you all here in South Africa and to welcome you physically and in person. But I guess we live in different and difficult times. And the human spirit has demonstrated its resilience. And with the help of technology, we are able to connect, even if it's in different ways. But nevertheless, we can continue to engage each other in meaningful ways. This is an important week in South Africa as well, so it would have been all the better to have had you here. On Friday, we celebrate what is called Heritage Day in our calendar of events. And on Heritage Day in South Africa, we, I suppose, marvel at the richness of the diversity that is South Africa. It's a diversity that, far from threatening to divide us, is a diversity that unites us. And it's an occasion where, in all our glory and in all our splendor, we reflect on our heritage, we reflect on our togetherness as a country, and we say to the world that notwithstanding the differences that we may have as people of the same country, we share much more in common that binds us together. So this indeed would have been a wonderful time to have had you here. But in any event, my role is a brief one in this session. And it's really to welcome you, which I've done, and to introduce really our special guest today, Justice Albie Sachs, who will be in conversation with Mohamed Keshavjee. I suppose I could speak for the rest of the day and maybe even tomorrow about Justice Albie Sachs, and words don't adequately describe the enormous debt of gratitude we all have as South Africans, and even those of us beyond South Africa, for him and for his life and for his work, for his passion and his principle and his commitment. I've been sent a narrative, and I'll try and read bits of it, Albie, but I might depart from it from time to time in the hope that for those who don't know you, when I'm done, they would at least get a better sense of you, even if it's a superficial one, but that will certainly change in the next hour in the discussion that you will have with Mohamed. But Albie Sachs started his career in human rights activism at the age of 17 as a second-year law student at the University of Cape Town, when he took part in the Defiance of Unjust Laws campaign, commonly known as the Defiance Campaign. 3 years later, he attended what has now become the Immortal Congress of the People at Cape Town, where the Freedom Charter was adopted. And for those of you who don't know, the Freedom Charter really formed at the basis of the ANC's negotiating stance when it negotiated with the then National Party in order to arrive at a transition to democracy in South Africa. Albie started practice as an advocate at the Cape Bar at the age of 21. The bulk of his work involved defending people charged under racist statutes and repressive security laws. Many of those faced the death penalty. He himself was the subject of considerable attention by the security police, subjected to banning orders, restricting his movement, and he was eventually placed in solitary confinement without trial for 2 prolonged spells of detention. In 1966, he went into exile, and after spending 11 years studying and teaching law in England, he worked for a further 11 years in Mozambique as a law professor and legal researcher. In 1988, he was blown up by a bomb placed in his car in Maputo by South African security agents, losing an arm and the sight in one eye. During the 80s, working closely with Oliver Tambo, leader of the ANC in exile, he helped draft the organization's code of conduct as well as its statutes. After recovering from the bomb, he devoted himself full-time to preparations for a new democratic constitution for South Africa. In 1990, he returned home, and as a member of the Constitutional Committee and the national executive of the ANC, he took an active part in the negotiations which led to South Africa becoming a constitutional democracy. And after the first democratic elections in 1994, he was appointed by President Mandela to serve on the newly established Constitutional Court, where he served with distinction for 15 years. In addition to his work on the court, he's traveled widely, sharing the South African experience in healing divided societies. He's also been engaged in the sphere of art and architecture and played an active role in the development of the Constitutional Court building and its art collection on the site of the old Fort Prison in Johannesburg. I just wish to add that in his judgments, I think all of South Africa was able to understand what the Constitution then had come to mean. His judgments didn't speak just to the legal practitioners, nor did it just speak exclusively to academia, but it spoke to ordinary South Africans in a language that they understood. It spoke to their fears and their aspirations. It enabled them to understand that this wonderful document that we called our Constitution was simply not a collection of wonderful phrases and commitments, but was capable of being converted into reality in making a difference in the lives of our people. And perhaps just to conclude this introduction of Albie, I read on his narrative that on turning 6 during the Second World War, Albie received a card from his father expressing the wish that he would grow up to be a soldier in the fight for liberation. I think we wish to continue to thank Albie for continuing to be a soldier in the fight for liberation. And I may dare to add that even if he hadn't received the card, having come to know Albie in the limited way I have, he would have nevertheless been a fighter in battle for liberation, because that's who he is and that's really his DNA. So welcome, Albie, and it's really an honor to have you here with us today. Albie, as I said, will be in conversation with Mohamed Keshavjee, and Mohamed Keshavjee comes from, I'm proud to say, grew up or was born in the same little district that I was born in, and that's Marabastad, just in the shadow of the Union buildings. It was a place consigned by the apartheid government, never to be heard of, but it was a place of great resilience, a community who demonstrated that despite whatever would be thrown at them, they would rise above that, and they would make a life for themselves, even in the dust and grime in which they lived. And Mohamed hails from there. He holds degrees from Queen's University in Canada and the School of Oriental and African Studies, the London University. He's the author of 4 books, and one of them is aptly titled Into That Heaven of Freedom, The Impact of Apartheid on an Indian Family's Diasporic History. He's also an international specialist on cross-cultural mediation with training from Harvard Law School, the Berger Foundation in Berlin, and Child Focus in Belgium. He has trained pastors and imams in mediation in the US and in the UK. He's also a former member of the steering committee of the World Mediation Forum, a position he held for 2 terms. He was responsible for conceptualizing and implementing the mediation training programs for the conciliation and arbitration boards of the Ismaili Muslim community worldwide, training some 1,500 mediators in over 25 countries in family and commercial disputes. From 2000 to 2012, he was keynote speaker at major conferences in various parts of the world, including Buenos Aires, Strasbourg, Paris, Galway, Eindhoven, Edmonton, amongst other places. And in 2016, he was invited by the Secretary General of the Hague Conference on Private International Law to Malta to discuss the 4th International Conference on International Interspousal Child Abduction. We helped draft the final resolution on mediation. He's a member of the advisory panel on mediation to the Secretary General of the International Social Service of Geneva, and holds a senior faculty position with the Darwin International Institute for the Study of Compassion, where he's lectured frequently. In 2016, he was conferred the Gandhi King Akira Peace Award at the 48th death anniversary of the Reverend Martin Luther King, where he presented the memorial lecture. He's presently based in London, where he lectures on law and mediation at the Institute of Ismaili Studies. There's also much more to say about Mohamed Keshavjee, but I think that would be enough by way of introduction of the two speakers. And without sort of letting you into what the next 45 minutes holds, but from where I sat, it's really allowing us to get up close and personal to Albie, understanding that even as a judge of the Constitutional Court, and even as he discharged that obligation to write a judgment together with his colleagues, there was this battle of what does this constitution mean? What does it mean to me? And what does it mean to the people of South Africa? And how does one, within the constraints that must come with the exercise of judicial power, continue to make it relevant? And I think in that sense, Albie, so many of us continue to grapple with that conundrum. We have an instinctive sense of what justice would require. And yet the oath of judicial office we take means that we must recognize the constraints of our power as well. So I'm certainly looking forward to this afternoon. And without any further ado, I'm going to hand over to Mohamed, who will then really get into conversation with Albie. So thank you very much. Over to you, Mohamed.
Judge Colopin, thank you very much for those very warm words. In fact, you've extolling the virtues of our struggle for freedom. But as a little kid, I remember your beloved mother being a fighter for apartheid, against apartheid, and was one of the passive resistors in 1947 when India took the case of South Africa to the United Nations. So your own background in the freedom for struggle has been nothing but phenomenal, particularly the struggle that your family has had to fight for justice. Judge Albie, wonderful to see you today. Welcome. Thank you for being with us on such an auspicious occasion. And I want to thank you most warmly because when I told my team that I'll try and see if I can get Albie Sachs to speak to us, everybody looked up and said, would that be possible? But as always, you are such a generous man with your time and sharing your experiences. So I'm not going to take too much time. I'm going to just zoom straight into the issue that you've had this remarkable role in the evolution of modern day South Africa, from being a lawyer, a fighter for a constitutional draftsman, if you may call it, a person who went to all these meetings where the future South Africa was being discussed. And then finally, you had the good fortune of being a judge in the Constitutional Court. So it must have been such a wonderful moment to see your entire struggle culminating in an ability to do something that could be meaningful. But obviously, in any person's life, there are always moments of frustration. Can you tell us about the case in the Constitutional Court that made you seriously thinking of resigning? I'm sure there must have been a moment where you said, let me pack all this up and get away. I can do something else. What was that moment, Albie? Tell us.
Yes, it wasn't to get away. It was a terrible moment in this wonderful 15 years with a lot of drama, a lot of excitement, challenges, and so on. But this was very, very special because I'd been asked by Arthur Chaskalson, the Chief Justice, to take charge of a case. It was called the Port Elizabeth Municipality case, a very boring title for what was a very dramatic case. And I looked at the papers and I read the record and I said, oh no, I can't. These were the facts. About 10 Black African families had been evicted from where they were living in their shanties. They looked for some open space and they found an area quite close to where they were working, very upmarket, overwhelmingly white suburb, and they put up their shacks there and were living there for several years until the owners of the beautiful homes nearby said, come on, this is our land. You can't just put up your shacks on our land. And they went to the council and asked the council to evict these families. And the council went to court, got an eviction order, and the case was taken on appeal. And on very technical grounds, the Supreme Court of Appeal said no, They were going to be evicted and sent to an area, particular area, and on technical grounds, they said, we don't know anything about that particular area. The municipality took the case on appeal to us. Now, this was our first evictions case. We'd had a case, Mrs. Grootboom, dealing with the right of access to housing of people who had nothing. And the South African Constitution allows for social and economic rights to be justiciable. And the right of access to housing is protected under the Constitution. The courts are involved in that. So in the Grootboom case, it was Justice Zak Yacoob, writing for the court, laid down the general approach that we had towards enforcing social and economic rights. But that wasn't an eviction case. This is an eviction case. And I said, I just can't. These were 12 poor families living on land that had been left vacant and unoccupied. They had nowhere else to go. And yet I've sworn an oath as a judge without fear, favour or prejudice to uphold the law, and you can't just come and put your shacks up on someone else's land. What to do? But if I can't fulfill my oath of office, then I've just got to leave. I seriously thought, I as Albie the judge, I'm obliged to say the technical grounds for not evicting them are very fragile. They've got to go. I as Albie spent all my life in what was called the liberation struggle, knowing we have millions of homeless people. And here we have people with beautiful houses on land that's not even being used for anything. It's vacant. They don't need the land. I can't do it. Albie, the person, the human being, can't reconcile himself with Albie, the judge. And if I can't do that, I must leave the bench. Fortunately for me, and hopefully for our jurisprudence, I was able to find in our Constitution an answer, because the Constitution that protects anybody from being deprived arbitrarily of property, that is the owners of the land, also protects the right of everybody of access to housing. And no one shall be evicted from their homes except by a court order taking account of all the circumstances. And was it just and equitable to evict them? And so now it's the irresistible force, if you like, of the owner's claim against the immovable force, object of the right to housing. And going into the history of the homeless people, of the people living in what we call the shacks, and the laws that we used, the criminal law being used to evict, now we have a new law, the Prevention of Illegal Evictions and Unlawful Occupation Act, that provides protection to people living in the informal settlements. You can evict them if it's just and equitable to do so. But what is just and equitable? What's just and equitable to the owners of the property is very unjust and inequitable to the so-called squatters, and vice versa. So I said, picking up on a provision of the Act, mediation should be tried. And that introduced me to mediation, which had never come before our court before. And I did some interesting research. Mediation used in labor law, it's used in family law to some extent, but not widespread in South Africa. And I used the phrase, what's needed is meaningful engagement, taking the form of mediation. And since mediation hadn't been tried, the eviction orders had to be stayed. And I imagined that what would happen in those circumstances, the white landowners could get together some money and find wherewithal, maybe a few hundred of them, to find alternative accommodation. And the council would also take the finding of alternative accommodation more seriously. In coming to that conclusion, I was compelled to go beyond the ordinary rules of property, to introduce the theme of Ubuntu, that the attack on the dignity of people being deprived of a home, a safe space, somewhere to live where you're protected from the rough world outside, where even if you're very poor, you have some element of privacy. Now that's being dislodged. It's not only their dignities that's assailed, it's the dignity of all South Africans, the rich as well as the poor, to live in a country where human beings are on the run all the time. They don't have a spot to lay their heads. And we have to approach the matter with the spirit of Ubuntu, the interdependence of people, not simply the rights of people, but the interdependence of people living in a community. And our Bill of Rights is nothing if it's not Ubuntu writ large. And so Ubuntu, through that case, was brought into the interpretation of our Bill of Rights. The matter didn't stay there, because in a later decision by Justice Zak Yaqub, he said, Albie, mediation is too weak. We need something stronger than mediation. Your phrase, meaningful engagement, that's the way to go. Because you could call for mediation, and if both sides don't agree, that's the end of the matter. The court must compel the parties to come together and tell the parties what they must engage on. And they can do it better than the lawyers can do, than the judges can do. Let them come together and see the poor, not simply as an anonymous mass, but as people, as families, as individuals, as human beings, engaging with the city council in that case, in the case he was dealing with, the bureaucrats, the officials doing very important work about movement of people and the restructuring of Johannesburg, but have to start thinking of the humanity of the people who are being moved and shuffled around. And so Zak introduced the concept of meaningful engagement as a mechanism for the court now to order the parties to get together and tell us in these kind of cases, what alternative accommodation are you going to offer? And the poor themselves have to be proactive. They can't simply say, we shall not be moved. They have to be proactive. They have to give the information. They have to look for alternative accommodation. And it introduced a whole new remedy that in some ways is stronger than mediation. It's a mediation that is compelled by a court order. You report back to the court as to what you've achieved. And so that gives them a compulsion to get together. If they can't agree, they just come back to the court and the court will make its order. They can't be compelled to agree on anything, but they can be compelled to negotiate. And so it was through that.
Sorry, you were able to bring in something outside the rigor of the law on the altar of justice.
It was not outside the rigor of the law. It was introducing into the law a new rigorous framework, a framework of engagement, of not simply the judges. Arthur Chaskelson said, you know, Albie, what we're doing here, we're doing more than simply declaring rights. We're managing a very stressful process in a constitutional manner, and that requires a different role for the judges, a more proactive role for the judges in a way, bringing the parties together, and yet the judges withdrawing in a way by saying the parties must now lock horns, if you like, and come up with a feasible, practical solution to the situation they find themselves in.
Thank you so much, Albie. I think that just throws a new light, because mediation sometimes is not effective unless both parties go for mediation. It does throw a new light on what we're going to be discussing this week. Albie, tell me, what was the application that you thought was the second most hopeless one to come to the Constitutional Court, but which ended up successfully with you writing the second most internationally quoted of all your judgments? What was that? Can you tell us?
Yes. And just by the way, for the viewers, these are questions that I asked Mohamed to ask me. So I've kept him in suspense, and to this moment, up to right now, he doesn't know what the answer is. And it's the case of S versus M, the state versus M. And it's a case, Mrs. M had committed credit fraud. She'd gone round to local shops, supermarkets, and so on, bought goods to the value of maybe a few £100. That would be £100 in those days. Not very much. She'd been prosecuted in the magistrate's court, given a suspended sentence, and she's out on a suspended sentence, and she does it again. And she's given bail, and she does it a third time. So she ends up being sentenced to 4 years imprisonment, 2 years suspended. And she comes to our court after an appeal to the High Court, and she says, no, I can't be separated from my children. I've got 3 boys. This is a gang-infested area, lots of drugs, and I have to look after them. And I looked at it. I remember saying to my clerk, this is the most hopeless case you can imagine. She's doing it again and again and again. She's been given every opportunity. And I make a recommendation to my colleagues. We can't hear this matter. It doesn't involve a constitutional matter, and she's got no chances of success at all. Hopeless. And my colleague Kate O'Regan said, but Albie, you look at it from her point of view, but what about the point of view of the children? The Constitution says every child has a whole series of rights, and their interests must be taken into account in any matter affecting the child. And that was quite a jolt for me. I said, okay, Kate, we can hear the matter. I don't think it's going to help on sentence at all. So we set the matter down for a hearing in the interest of the children, not of the mother, interest of the child. By the time the matter came to the court, we had got social workers' reports, some from our side, some from the state. And it turned out by then, Mrs. M was now running 2 small businesses. One was a laundry, the other was a bail business. She knew all about bail. She was on the Parents Teachers Association, the school governing board. She was living a model life. And I thought, sending her to jail, what good is that going to do anybody? So the whole theme of restorative justice came to mind. Again, it's softening the rigor of implacable law. It's humanizing the law. And the restorative justice would then benefit the interests of the children. The outcome was that we made an order now, instead of sending her to jail, that the jail sentence be suspended completely, that she be ordered to pay back to all the people she had defrauded the money. We could just imagine the surprise of the Pick and Pay, the Pep stores, whatever it was, that she comes back to pay back the money, that she'd have to get counseling. There was something desperate in her conduct. And also she would have to do community service, ordered by the community service officers. Not all my colleagues went along with me on the order. They all agreed, the most important thing coming out of it, that in all cases involving children of people about to be sent to jail, the court is under a duty. The court is under a duty to protect the interests of the children, to make sure somebody to look after them or to find alternative care. Now, I mentioned that in relation to the conference on mediation. It doesn't directly involve mediation, but it's an alternative form of alternative dispute resolution, if you like, in the context of criminal law. It's a different way. It's not the state through the courts finding a solution to a crisis, if you like, a little crisis in the society, social fabric. It's the community itself being involved. I find a connection with the concept of mediation, that idea of people themselves being enabled to find solutions that are meaningful. and it's a reintegrative thing, whereas so much of the civil and criminal procedure is calculated to, whether intended or not, to separate the parties, to keep society more divided, to encourage anger, hatred, a sense of victory and defeat, as against the concept of bringing people together, that spirit of Ubuntu, of reconnection. And I might say that that case has been picked up by children's rights people throughout the world. The rights of children of prisoners, those children to have their rights taken account of and not seen simply as the unfortunate collateral damage of decisions of sending people to jail.
Wow. Albie, thanks for that. I mean, restorative justice is at the heart of alternative justice. In fact, I think much more has to be done on the criminal side. Most of ADR is on civil litigation and commerce and maybe family law, but not so much on the criminal side. Albie, tell us, what about the moment during your time at the bar that you felt most ashamed of being a legal practitioner? You know, Henry Brown, our mutual friend, has just written a book called The Odyssey of a Lawyer. And he's called A Lawyer's Odyssey, Apartheid, Mandela, and Beyond. And Henry mentioned some of the cases that were referred to you and the ludicrous situations that you found yourself in under different banning orders at different times. And that I wanted to know that during your time at the bar, what were you most ashamed of being a legal practitioner?
Yes, this was a very rare case for me. It was well paid. Most of my work I did for nothing. I couldn't take money from people who were being prosecuted under unjust laws. But every now and then, I got a little kind of low-hanging fruit case. And this one, I was junior to one of the top silks, senior advocates in Cape Town, and it was a divorce case. And I found it grueling. A brilliant lawyer on our side, brilliant lawyer on the other side. We were for the husband. And the battle was to try and crush the wife because she was claiming half the property, and to expose her because she'd slept around, putting private detectives on her tail, and to get a better settlement. And it was, to me, appalling at a human level. And there were counter arguments from the other side. And I felt, what are we doing as lawyers? We're drumming up tension and anger, so damaging. People, their marriage had broken up anyhow. And now, because of things that had nothing to do with the actual marriage, but everything to do with the division of property, they were going to have hatreds forever, and the children would be affected by it. I felt so ashamed to be a lawyer. I went along with it. My duty was to shut up, to help the senior counsel. To make it worse, all of us happened to be from the same social community. They even knew the parties concerned. And instead of that being a factor that led to softening the brutality of the allegations, and they knew the case would be settled. You as counsel, you drum up the battle, push the day before. When you've got your fees for going to court, you're really going to get your fees, but you know it's going to be ugly in court. You're not going to go to court. It was like a charade. I felt so ashamed to be a lawyer, to be an advocate in those circumstances. We were destroying human happiness in the name of upholding the law.
That'll be the last question in this group before we open up it a little bit more. How did how did a young attorney who used to carry briefs to you when you practiced at the bar in Cape Town end up disconcerting you twice, first in hell and then in paradise? Could you describe what happened?
Okay, I'm going to spill the beans now. That young attorney was Henry Brown. who's sitting close to us right now.
Henry, don't
And,
leave.
and now he looks like a very sage, wise elder. But, you know, if somebody's been a junior to you, he's a junior to you for the rest of your life, even although his books have sold 10 times more than any of my books have ever sold. Any event, I've been locked up, I'm thrown into solitary confinement. That's very, very disconcerting. And I think on the second day, I get a message. The police say, your attorney is here to see you. And I'm so happy because you're locked up in solitary, you've got no one to speak to, you feel totally lost, cut off. And it's Henry Brown comes in. And then he does something very strange. He's allowed in to see me to tie up the loose ends of cases I was involved in at the time. Purely legal kind of a thing. And we start talking about some cases, part-heard cases, so that he can hand over to the other lawyers taking over. And suddenly he starts striding up and down in that little cell that I'm in. And this looked very odd, very strange. He's not even looking at me. Walking to the left, walking to the right, writing something down. And I'm very disconcerted. In the event, he leaves. Days later, the station commander comes in with a piece of paper, and I read on it. And by then, the only book I had was the Bible. So I'm reading these two columns down the page, but I can't read across. But across the page, it says in the Supreme Court of South Africa, Cape of Good Hope Provincial Division, and I go on reading, it's hereby ordered that the applicant, Albie Sachs, be allowed reading matter and writing material. So I've thanked you before, Henry, many times, but I'm thanking you publicly. And the reason why he was walking up and down while I was in hell was to measure the space that I was in for his affidavit. For the affidavit. So that's the encounter in hell. Encounter in paradise, what was pushing a little bit calling it paradise, but comparatively. Decades later, I'm in London and I'm reconnecting with Henry. And I'm excited to do that. You know, there's a bond that you have that lasts for the rest of your life. And he says, will I come up to his office? I think it was quite close to the river somewhere. And we're reconnecting now after a long, long time. We'd been connected before, but haven't seen him for a decade or more. And I ring the bell and he opens the door and we sit down. I think, what's going on? We're sitting in the waiting room. I thought I'd come to see you in your office. And we're talking and I'm waiting. And it slowly dawns on me, this is his office. It's not a lawyer's office. There's no desk with Sir sitting behind the desk and the client coming in, bowing and being grateful to get an audience. We're just sitting around and chatting. For people not familiar with the unconscious protocol of law, I think they don't even know what I'm talking about. So what? You know, it was a simple casual office. For those of us steeped in the practices and the habits, an office is an office. It must look like an office. It must have somebody in charge. And he's destroying all that by the very physical space in which you're functioning. And Henry introduced me to mediation. But I needed that experiential shock to open up my imagination to a new way of looking at resolving legal disputes. Sometimes these tiny little details are more important than the grand schemes. Perhaps because they're habitual, they're unconscious, they're so telling and so affecting. And it was wonderful to hear about what was being done. It was taking a lot of the brutality and sting and bitterness out of law, not to mention the time, the psychological energy going into it, the stress. Law shouldn't induce stress. Law should be a stress reducer, not a stress inducer. And yet I knew people who were proud businessmen, ruthless in business, and they would turn to jelly if they had to go and testify in a court of law. There's something terrifying about the court of law, something about its implacability, its inhumanity, even to the boldest people, the proudest people in our community. So I became converted to the very concept of finding alternative dispute resolutions that provided for more dignity for the persons involved, that took the bitterness and stress and the long delays out of it, that allowed the courts to focus on matters where you had to have evidence under oath, you had to have cross-examination, you had to have trials, focus on that. But the other issues that can be resolved through alternative dispute resolution in the criminal sphere, through diversion, through bringing in the communities, in the civil sphere, through enabling people to find the better sides of themselves. But the better sides and the more pragmatic and practical sides of themselves that reduce sting and bitterness and expense, so much the better. And Mohamed, it's wonderful that you and others have organized this conference. South Africa was the polecat of the world. We were the worst country of the world in many ways for official racism through apartheid. We ended up with maybe the most progressive constitution in the whole world, partly as a reaction. And we pioneered lots of marvelous things. Our Truth Commission was exceptional, bringing people to come out and convey and speak the truth, to acknowledge what they'd done, allowing the emotional side of experience, not just the statistical side and evidential side to come through. But in terms of mediation, we are far behind. We are far behind, far behind. And it's so needed. It's so needed in South Africa. And it's marvelous that you're involving people in the legal community, in themselves, being able to engage with the work that you've done. I went to Western Australia once on a speaking tour, and I met Baptist, gosh, I forget his surname now, who specializes in mediation. And he was telling me in Australia, 60% of civil matters are dealt with through mediation. It's a huge amount. It's not the occasional thing for labor law and for family law. That's your point of departure. That's the way to go. And it was so beneficial and so well accepted. Ultimately, I think the lawyers resisted for a long while, but ultimately they bought into it. And now they can focus on other matters in other ways of earning good incomes. It's so much more healing and rewarding. It's not only pragmatically useful, there's something of the Ubuntu style and spirit that we speak about so much in South Africa that's captured by the concept of mediation. So I really wish you all a very, very good conference. You've got some of the South Africans who don't know, people like Mohamed and Henry Brown and so on have become world experts, world leaders in this sphere. It makes me feel so proud as a South African. But I think partly your interest comes from not the concept of Ubuntu expressly, but that spirit of human solidarity we developed fighting apartheid, trying to imagine a better world, a better South Africa, and a better legal system. I think that's informed both of you in the work that you're doing. So I wish this conference every success.
Albie, thank you so very much for your warm words of encouragement. I think it was an American academic, Kerry Mankell Maddow, who defined mediation as having a limitless remedial imagination. But I would say that this limitless remedial imagination has to be embedded in social justice and ethical values. And Albie, as a lawyer, as a judge, as a freedom fighter, as a great ardent champion for human rights, you have always looked at law not as a legalistic concept. You've looked at law in the context of what justice it can bring about. I want to thank you most warmly for opening your heart to us, telling us what you saw the law being capable of doing, and how an ethical, Ubuntu-oriented orientation can bring about justice to those who are most marginalized in society. We have done extremely well in time. And I must say, I was amazed. I didn't know what you were going to say. I was wondering who was this young lawyer who used to carry your bags. And when I spoke to Henry Brown, I said, Henry, let's come and listen to Albie. And I hope, Henry, I didn't mislead you into some sort of a story. But I'm so happy that we've all been able to connect with such a beautiful connection. And let me just also mention, Albie, that the 20 international trained team that are doing this are all doing it purely pro bono, just because they love to produce peacemakers. And we were inspired very much by the Aga Khan's vision that he said, if you have education and knowledge, it becomes an albatross on you if you don't share it for those who are less fortunate in society and who are in need. But this is not only a Muslim principle, it's a Jewish principle, it's a Christian principle, it's a Hindu principle, it's a principle of Ubuntu, it's a principle of all cultures. And hopefully in the next 2 weeks in South Africa, with the team we have got together, we hope that we will be able to make a little difference in the adversarial culture, veering towards more a negotiative culture, embracing people, in allowing them to come about a settlement which resonates their own spirit so they can be human again. On behalf of everybody, Albie, thank you so much. You do not imagine how much people hold you in esteem and love. And our good wishes are that may you always be happy and have a good life for all the years that you may have on this earth. Thank you so much for being with us today, Albie. God bless you.
Thank you. Ben, thank you.